Welcome to Journey to Esquire, the podcast. I'm Jocelyn Hardrick, founder and president of Diversity Access Pipeline, Inc., the company behind this podcast and other great programs, like Journey to Esquire Scholarship and Leadership Program, which provides $2,000 cash scholarships to third-year law students and internships to second-year law students, along with leadership training and mentors. And Journey to Esquire, the blog, which provides insightful articles to help navigate you through law school and beyond. Find out more on our website, www.journeytoesquire.com. Hi, it's Jocelyn Hardrick, the founder and president of Diversity Access Pipeline, Inc., the nonprofit behind this podcast, Journey to Esquire, the podcast. We have another great guest for you today, Aliza Shatzman, who's the president and founder of the Legal Accountability Project. It's a nonprofit aimed at ensuring that law clerks have positive clerkship experiences while extending support and resources for those who do not. Aliza earned her bachelor's from Williams College and her JD from Washington University School of Law. After law school, Aliza clerked in DC Superior Court during the 2019 to 2020 term. Interestingly, in March 2022, Aliza submitted written testimony for House Judiciary Subcommittee hearing about the lack of workplace protections in the federal judiciary. She now writes and speaks regularly about judicial accountability and clerkships, and we're going to hear a lot more about her clerkship experience. But first, we're going to talk about her journey to Esquire. Welcome, Aliza.
Thank you. Thanks for having me on the show.
Thanks for reaching out to us to be on the show. You know, one of our goals for our scholarship and leadership program is to encourage more students to enter judicial clerkships because it is a place that opens a lot of doors and leads to a later judicial career for some people. And also is a great learning opportunity, but there are some caveats. So we are going to talk about that later. So let's talk first about why you decided to become a lawyer.
Yeah, so I went to law school thinking I wanted to be a reproductive rights litigator. I always had a strong sense of moral outrage, particularly on injustices affecting women. So I definitely went to law school thinking I would do public interest litigation.
So around when did you decide that? Is it when you were kind of in high school or college? What made you choose the law specifically as well?
Yeah, early in college. I think I went to college thinking I wanted to be potentially an OBGYN. The science courses at Williams were hard, and so I kind of course corrected. I did some different political internships, interned on the Hill, and then I interned at Planned Parenthood in Philadelphia and was really just galvanized to action by some of the personal stories that I heard. So I went to law school thinking I wanted to do that, but I did take a couple of years between Williams and WashU, interned and then worked on the Hill, tried to get some other experiences.
Oh, excellent. Yeah, so that's a lot of people's stories, right? They start off with one thing, but they're passionate about something and they find their way to law. So describe your law school application process for our listeners.
Yeah, so I took 3 years between college and law school, took the LSAT twice, as I imagine many people do. Knew that I wanted to probably stay on the East Coast for law school, applied to probably 20 schools. So my 1L year at UNC Law, and then knew pretty early on that I wanted to transfer. And so I planned to and did transfer to WashU Law after 1L year.
So how many law schools, when you initially applied, did you apply to? And what was that experience like of choosing UNC?
I applied to at least 20. I chose UNC candidly because it was the best law school I got into. I worked really hard studying for the LSATs and invested a lot of time, but I just didn't do very well. That was hard. I kind of felt like my efforts were kind of wasted a little bit, but that was okay. UNC was a fine place to start, and I knew that I had the option to transfer if I was unhappy or did well and was unhappy. Yeah.
Oh, good. Yeah, that's a lot of people's experiences. Like you said, a lot of people take the LSAT multiple times. There's been all that big debate about getting rid of the LSAT. They said they would, and then all of a sudden they changed their mind and said it's back on. A lot of debate about whether it truly measures someone's ability. And like, for example, you and I, who didn't do, super high scores on the LSAT, but come out and are excellent attorneys despite that. So that's the great message for our listeners. Don't let the LSAT kind of deter you from achieving your dreams.
Schools say that they look at applicants holistically, and perhaps they do. But I think at the end of the day, particularly in the T14, it really is a lot of focus on the LSAT, which is really unfortunate, especially because some of those schools have the best programs for public interest litigation, the types of careers that I had aspired to. And so I think that's kind of unfortunate.
Yeah, it's interesting that you kind of have to spend a lot of money to do public interest law. I always thought that was weird because I had a strong interest in public interest law. And every time I tried to get internships or things, they'd be in a different city and they said, yeah, it's unpaid. I'm like, well, but I have to pay rent. I have to drive. I have to, it's almost like you already have to have the money in order to do public interest litigation.
That's such an important point. Yes. I did various unpaid internships throughout law school, which we will talk about, that were public interest focused. But yes, I think law school really incentivizes folks to go the big law route, which is never something I wanted to do. But I mean, I did not have law school loans, but many people do. And it kind of incentivizes a certain path, which I think is sad because a lot of people go to law school wanting to do public interest work, focus on issues they care about. That's not what they end up doing. And certainly the money is a big part of it. The unpaid internships, the loans that need to be paid off. And the fact that public interest loan forgiveness programs, both the federal ones and the ones that law schools do, just seem pretty inadequate based on the experiences I know from my friends and colleagues.
Yeah, and it's in the news now, right? Because the president's trying to forgive a very small amount compared to what people have, and there's a lot of stumbling blocks. So, but it's good to know that there's scholarships available because you said you didn't have loans. It is possible to graduate without student loans. So, did you enjoy law school? It sounds like you had a lot of hands-on experience based on the internships you mentioned.
I did. So I started at UNC, was not super happy there, knew that I was transferring to WashU. I did 4 different internships throughout law school in various components of the Justice Department. My 1L summer in the Office of Vaccine Litigation, 2L spring in the U.S. Attorney's Office for the Southern District of Illinois, 2L summer at ATF, and then 3L fall in DOJ's counterterrorism section. I liked WashU. I had great professors and mentors, made good friends, definitely had a lot of hands-on experiences doing different externships and clinical opportunities, so those were important. Looking back now, based on my clerkship experience, which we'll talk about, kind of makes me think about my time at WashU a little bit differently, but at the time I did enjoy it. It was challenging. I worked hard. I was very focused on building up my career as a prosecutor. That's what I wanted to do from pretty early in law school. I was very focused on that goal. Internships, I was a journal editor, built relationships with professors who could write recommendations, and did all the things to set myself up for success.
Yeah, and there's a lot of law students don't know what all the things are. So you just listed some really good things that can generate good job offers. But a couple of things, you're using a little alphabet soup there, ATF and DOJ. What are those departments?
DOJ is the Department of Justice, and ATF is the Bureau of Alcohol, Tobacco, Firearms, and Explosives. I knew that I wanted to be a homicide prosecutor in the DC U.S. Attorney's Office. Very specific career goal, and I wanted to get a breadth of criminal law experience.
Oh, that's excellent. So those are both kind of law enforcement geared departments, and the U.S. Attorney's Office is under the Department of Justice. So it's surprising. A lot of students don't know the federal level of prosecution. They know state court, the assistant state attorneys or district attorneys, but I'm like, there's this whole world out there in the federal field, and there's a federal public defender. So just something to keep in mind.
And the DC U.S. Attorney's Office is unique because their entry-level prosecutors prosecute local crime in the District of Columbia. So that was kind of my interest in it.
Oh, excellent. Yeah. So what was your job search like after law school?
So I planned to clerk and did clerk after law school. So I was applying for federal clerkships before the Oscar plan was in place. So now most students cannot apply for a federal clerkship if the judge hires on plan until their 2L summer, until June of their 2L summer. I was pre-plan. So I spent 2L spring sending out lots of applications for federal clerkships. I sent about 100 paper apps out. WashU helped with that. It was because primarily I was a transfer and I didn't have grades yet. And so that kind of, made the process a little bit more challenging. I spent my 2L summer and 3L fall in DC. And that's when I really decided that I wanted to clerk in DC Superior Court. So I kind of transitioned myself to applying to lots of judges in that courthouse. I remember like the first week of my 3L fall DOJ internship, it was across the street from the DC Superior Courthouse. So I literally walked my applications over, interviewed and accepted a clerkship 3L September. And then I planned to clerk for a year and then apply to the DC U.S. Attorney's Office, recognizing that I needed 1 year of work experience to be eligible to apply to the DC U.S. Attorney's Office or any other federal government position. And so when we think about the messaging around clerkships now, it's very much considered a necessary checkbox for your next legal job. Many jobs have in the posting say you need 1 year of work experience. That's really a euphemism for a clerkship expectation. So
yeah, pretty much.
I accepted the clerkship intending to launch my career as a homicide AUSA in the DC U.S. Attorney's Office, knowing that DC AUSAs, federal prosecutors, appear before DC Superior Court judges.
Yeah, so help our listeners understand, because DC is this weird, it's a city, but it's not a state and it's not in any state. And I think with Justice Jackson recently going to the Supreme Court, that the DC circuit kind of started getting into people's minds. What is it, a state court or a federal court, and how does that work?
So I write about this a lot. I argue that it is an Article I federal court. The DC courts, DC has two local courts. DC Superior Court is a local trial court. The DC Court of Appeals is the appellate level, the highest level state local court. But we also have federal courts, the DC District Court and the Court of Appeals for the District of Columbia. Those are Article III federal courts. DC Court's judges are Article I federal judges. Article I of the Constitution creates some additional judicial positions. The DC courts, as well as the Court of Federal Claims, as well as the bankruptcy courts, those judges are mostly, including in DC, Senate confirmed for 10 to 15-year terms, which confers upon them some special protections, and they are, like Article III life tenured federal judges, exempt from Title VII of the Civil Rights Act. So it can get quite confusing. They're Article I judges. Most people consider DC courts to be hybrid state federal courts. They also hear cases on local crime, but the DC laws are such that there are some federal penalties. If you are convicted in a DC court, you go to a federal prison. So it's an interesting mix.
It is. I think I saw recently that I think the mayor of DC or some other people were lamenting that they didn't clarify some of these laws because people are getting tripped up. It's unclear what the penalties are, what they're guilty of, and that's causing a lot of unnecessary prison time and risk-taking, frankly, from people who, may be thinking they're committing a minor crime and end up in federal prison.
Yes, we also have a lot of federal law enforcement patrolling the streets of DC, which makes it confusing. Not that anybody should be out there planning to commit a local crime, but it does create some challenges. And now DC is in the news because DC is trying to clarify some of those criminal penalties. The thing about DC judges, though, is that they are Senate confirmed, unlike other state court judges, and they're regulated by the DC Commission on Judicial Disabilities and Tenure. It's a very toothless regulatory body. I just testified before the DC Council a few weeks ago about this. DC judges are not disciplined for misconduct, for mistreating their clerks. And the fact that these judges are Senate confirmed confers upon them some special protections. I think the DC Commission that regulates them perceives it to be a higher bar to remove them from office because they are Senate confirmed. That is wrong.
Okay, so we're going to go into that because we talked about you getting your clerkship with the DC Superior Court.
And then you got me on my soapbox about DC judges, which I could talk about all day.
Well, we want to make sure our listeners understand the relationship, right? Because that's important. Part of what you're talking about.
Yeah, I mean, there are 94 federal courts, and then there are the DC courts, it's one of the fanciest and most prestigious, quote unquote, state court clerkships. And I encourage everybody to consider clerking. Everybody who wants to clerk should, but you need to go into it with eyes wide open. And I did not realize the enormous power that a judge would have over my career and the enormous protections conferred upon DC judges because they are Senate confirmed. So it is really about increasing access to information for all students who are considering a clerkship. And there is just a lack of information out there right now.
There is. And as someone who has clerked, there's so much confidentiality required. And like you said, they hold a lot of power. So not a lot of people are willing to speak out on issues of harassment or mistreatment, but it has been in the news lately, right? There was the Supreme Court leak, so there was something going on there. There's also been, besides yourself, other people have been talking about sexual harassment and other issues within their judicial chambers. So let's get to your specific experience. Talk to us about what happened when you went into your clerkship in 2019.
Yep, so I started this clerkship in August of 2019, as we talked about, intending to launch my career as a homicide prosecutor. Started this clerkship, and beginning just weeks into it, the judge for whom I clerked began to harass me and discriminate against me because of my gender. He would kick me out of the courtroom, telling me that I made him uncomfortable and that he just felt more comfortable with my male co-clerk. He told me that I was bossy, aggressive, nasty, that I had personality issues. The day I found out that I passed the DC bar, so big day in my life, he called me into his chambers, got in my face, and told me, "You're bossy." And I know bossy because my wife is bossy. I was just devastated. I mean, this was my first job out of law school. The judge seemed to be singling me out for mistreatment. I wished I could be reassigned to a different judge. My workplace in the DC courts did not have an employee dispute resolution or EDR plan in place that might have enabled me to be reassigned. And as we talked about, I knew that I needed a year of work experience to be eligible for my dream job at the DC U.S. Attorney's Office. Confided in some attorney mentors who advised me to stick it out, so I tried. We transitioned to remote work during the pandemic. So in March of 2020, I moved back to Philadelphia to stay with my parents, worked remotely. The judge basically ignored me for 6 weeks before he called me up in late April and told me he was ending my clerkship early because I made him uncomfortable and lacked respect for him, but he didn't want to get into it. And then he hung up on me. So I reached out to DC Courts HR, and they told me there was nothing they could do. HR doesn't regulate judges. Judges and law clerks have a unique relationship. Then they asked me whether I knew that I was an at-will employee. So then I reached out to my alma mater, to WashU Law, seeking advice, support. Found out that this judge had a history of harassing his clerks, that law school administrators, including the clerkships director, who still works there, and several professors, knew at the time I accepted the clerkship. They decided to withhold that information from me because they wanted another WashU Law student to clerk. So this was all really devastating. It took me about a year to get back on my feet. I applied for jobs and had interviews, but questions were asked about why the clerkship ended early and why the judge wasn't listed as a reference. Eventually secured my dream job in the DC U.S. Attorney's Office, and I moved back to DC in the summer of 2021, intending to launch my career as a homicide prosecutor. I had drafted a judicial complaint that I intended to file with the DC Commission on Judicial Disabilities and Tenure, but I wanted to wait till I'd secured a new job. I was already worried the judge would retaliate against me. So I was 2 weeks into training at the USAO. I'd already started working there when in July 2021, I received some pretty devastating news that altered the course of my life. I was told by USAO leadership that the judge had made negative statements about me during my background investigation, that I wouldn't be able to obtain a security clearance, and that my job offer was being revoked. So I remember crying on the phone with USAO leadership, DC Courts leadership, trying to explain the situation. They said there was nothing they could do. The decision was final. They wouldn't tell me what the judge had said about me. even though it was a reference about me that had led to the revocation of my job offer. A couple days later, the USAO reached out, invited me to interview for another job with the office, but then they revoked that too, based on this judge's same negative reference. I was 2 years into my legal career. This judge just seemed to have enormous power over my life and career. So I filed a judicial complaint with the DC Commission on Judicial Disabilities and Tenure. I hired attorneys, and in the summer and fall of 2021, participated in the investigation into the now former judge. We were partway through the investigation when I found out the judge was on administrative leave, pending an investigation into other misconduct at the time he'd filed the negative reference about me with the USAO. USAO was never alerted of those circumstances, and in January 2022, pursuant to the terms of our private settlement agreement, separate from anything the judiciary can or would do for a law clerk, the former judge issued a clarifying statement to the USAO, addressing some but not all of his outrageous claims about me. But by then the damage had been done. It had been way too long. I was pretty much blackballed from what I thought was my dream job. And during the summer, while I was participating in this judicial misconduct investigation, I became aware of the Judiciary Accountability Act, or JAA. That is proposed legislation that would extend Title VII protections to judiciary employees, including law clerks and federal public defenders. Currently, folks like me are exempt from Title VII. We cannot sue our harassers and seek damages for harms done to our lives. So I reached out to a bunch of House and Senate offices involved with drafting that bill, shared my experience with them, advocated for the legislation, advocated for an amendment to cover the DC courts, as we talked about their Article I federal courts, currently not covered under the JA. Stayed in touch with them, and when a House Judiciary Subcommittee hearing happened in March 2022, I was invited to submit written testimony, sharing my experience in advocating for this legislation and the amendment I just mentioned. And in the weeks following that, the response to my public statement was very positive, and so I began tossing around some ideas for further advocacy work to protect law clerks from workplace mistreatment and to address various injustices in the legal profession and the judiciary that I personally experienced, including a lack of transparency in the clerkship application process and a lack of accountability for judges who mistreat their clerks, which eventually inspired me to launch the Legal Accountability Project in June 2022.
Okay, so let's unpack a little bit, because that was a lot.
It was a lot. Imagine what it was like to live it.
I know, I mean, it takes a lot of courage to do what you did after realizing the amount of power that particular judge had to continue, right? Because you can see how that could trickle into other things. So first I want to talk about, that's a big thing that people ask a lot. What do I do if I'm in an environment experiencing unjust behavior or harassment or things that are clearly ethically or morally wrong? And what should I do? And you did a lot of those things people tell you to do. Speak to your mentors, speak to your law school, speak to trusted advisors, and allow them hear what you heard. Suck it up, buttercup. Everyone goes through this, and you just have to, deal with it. What is your advice to people who might be hearing that?
I feel so strongly about this. This is a great question. I spend a lot of time now speaking with law schools about LAP's initiatives, and troublingly, I hear from a lot of law school admins, particularly clerkship directors, sometimes deans, things like what I heard from female attorneys when I was preparing to file a complaint and speak publicly. The right professional decision would have been not to report. Speaking publicly will tarnish your reputation. Heard from a couple admins, Aliza, you spoke publicly, but most people just want to keep their heads down and move on. I hear that predominantly from female clerkship directors, and that is outrageous, terrible advice. You should not do that. The right professional decision is to report. And female attorneys tell me, female professors and admins who give this advice, that they are preparing female attorneys for the culture that is. I think that is wrong. We should be preparing the next generation of attorneys for the culture and the profession that should be. If you are experiencing mistreatment, you should absolutely reach out. And the advice is different in the judiciary versus other aspects of the legal community, because as we talked about, judiciary is exempt from Title VII, but there's also a really outrageous lack of workplace protections through EDR, through EEO offices, through HR offices, directors of workplace relations, as well as a really troubling lack of enforcement of the Judicial Code of Conduct, as well as the Judicial Conduct and Disability Act, which is the federal complaint process. So the first thing you want to do is try to get yourself out of the situation. If you are a federal law clerk, that's going to involve an employee dispute resolution or EDR complaint. You might need to seek legal counsel. It is challenging for law clerks to find attorneys. Attorneys are notoriously unwilling to take on these types of cases. I'm very grateful for everything my attorneys did for me. And one thing I'm working on at the Legal Accountability Project is an employment attorney database to connect mistreated law clerks with attorneys who can help. You need to reach out to the EEO office or HR, file a complaint, get yourself out of the work environment. But I don't think it is ever the right decision to stay silent, because as I speak with a lot of law clerks right now, I see the emotional toll, the really significant emotional toll that staying silent takes on these clerks. And I have to say, this might not be the most popular opinion, but I have found speaking publicly to be quite empowering, not only because of the positive response, and I imagine that is part of it. The number of people who reach out to me every day to thank me and confide in me is certainly gratifying. I did not receive formal redress through legal channels, but by sharing my experience, I do feel that I receive redress in that way. And I think it's really sad that law clerks would just want to move on. I know that judges probably will not be disciplined through the formal complaint process, but speaking publicly, sharing our experiences is the way we change the culture to go from one of deifying judges and disbelieving law clerks to one of empowerment, encouraging everybody to bring their full selves to work every day. And while there are lots of things I advocate for at LAP, including legislative change, increased transparency, accountability, other initiatives, larger cultural change in the legal community is probably the most important and also the biggest boulder I push up the hill every day.
Yes, I mean, that's what Journey to Esquire is trying to do, right? We create lawyers who lead, mentor, and inspire so that when they become leaders, they're taking these things into consideration and they're creating environments where everyone can prosper and not have to worry about going through what you went through. Now, what if someone, now it sounds like in hindsight, there was justification in you going forward and doing your complaint because the judge has been removed, and you said it was a confidential settlement agreement, so we won't go into that. But what about students who are afraid of being blacklisted the way you were and concerned about their prospects because they have six-figure law school debt and they may be concerned that they're not able to find a job after that? What would your advice be to them?
I would say two things about that. The first is that it's definitely important to get yourself out of the work environment or try to find a new job before you pursue some of the things I did, if you can. But the other thing I would say is this. There is no guarantee that if you decide to stay silent, the judge who mistreated you during your clerkship will stop mistreating you. It is unclear how much the former judge knew about my involvement with HR at the time he filed the outrageous negative reference about me. It is very possible he just did it because he hated me and he knew this was my dream job and that he could thwart it. And he did. There is no guarantee that a judge will stop mistreating you if you stay silent. So why not speak out? Why not take action? I worry when current law clerks facing mistreatment reach out to me a lot and they talk about experiences like mine and they say, I just want to put my head down and get through it. There's no guarantee you're going to get through it. Judges have enormous power. They perceive themselves to be above the anti-discrimination laws they enforce. So what's going to stop a judge who's unhappy with a clerk, unhappy with their performance in the job, from taking further action once they leave the job?
That's a good point. So just to make sure we don't scare everyone away from judicial clerkships.
That's not my intent.
Yeah, and I'm sure you want access, you want information, transparency, and
there's
just like
one
anything.
clerkship director who keeps telling people that I want to abolish clerkships. I'm not sure why she does that.
Wow. Yeah, I mean, it's a lot like what we're hearing generally, right? If you criticize something, people think you want the whole thing to go away. That's not the case. We're saying this is great.
A friend said recently, you're critiquing in order to make better.
Yeah, and then if you care, that's what you do. If you didn't care, you just walk away. Like you said, you'd walk away and move on with your life. Right. What would you say are if you have these statistics, kind of percentages or the trends of this kind of workplace harassment happening in clerkships? Is it high, low, in the middle, or is it unclear because of lack of transparency? What do you know?
Great question. There is a real lack of data in this space, as well as a lack of data on diversity in clerkship hiring that enables judiciary leadership to disclaim responsibility for and discount the scope of these problematic behaviors within the judiciary. The federal judiciary has been notoriously unwilling to conduct a workplace culture assessment that could quantify the scope of these problematic behaviors. After about 5 years of advocates poking at them, they recently agreed to conduct one, but they have specifically not committed to reporting the results publicly, which is an enormous red flag. Sometimes an individual circuit will conduct one for internal policymaking purposes, and Ann Merrimau reported in the Washington Post on the 2021 survey conducted in the DC Circuit, one of our 13 federal circuits. In that circuit alone, in 1 year, 57 judiciary employees experienced harassment or retaliation. An additional 134 witnessed or heard about problematic behaviors. That suggests a problem we need to address. And I suspect there is a substantial undercounting because people perceive if the judiciary is conducting this data collection, perhaps not confidential, perhaps I might be retaliated against for sharing my experience. Those data definitely suggest that there is a problem we need to address, but there's an enormous data mismatch between those figures and the fact that fewer than 10 each year, formal complaints are filed under the Judicial Conduct and Disability Act by law clerks. Why? Law clerks fear retaliation, they fear reputational harm in the legal community, they're actively dissuaded by various folks in the legal community from filing complaints or speaking out against the judges who mistreated them. I definitely think these issues are pervasive and unaddressed in both the federal and state courts. One thing LAP wants to do is various data collection analysis activities to quantify the scope of these problematic behaviors. Quantifying the problem is the first step toward crafting effective solutions, and we really need transparency because there is the type of mistreatment I am talking about: gender discrimination, harassment, retaliation. There's also judges who are creating an overly hierarchical work environment and saying law clerks cannot work remotely, cannot take vacation, they must stay till 9 p.m. even when there's no pressing work to be done at 9 p.m. They won't let you take a phone call or go to lunch. Those are problematic too, and we need some data on that as well. As I've said a couple times on this podcast, not dissuading anybody from clerking. Clerking is an excellent opportunity. But you have to be mindful about the work environment you're entering into. And there is no transparency about excellent judges and safe work environments to apply to, and not so great work environments to either avoid entirely or go in with your eyes wide open, knowing the type of boss you will be working for. Most law clerks just have no transparency on the type of judge they're accepting a clerkship with. And I think that is really leading to a lack of diversity in the upper echelons of the profession as law clerks face mistreatment in their first legal job and then think twice about pursuing the careers that they dreamed of.
Yeah, that's a good point. So before we go into some of your contact information, because definitely want to have that available, what would you recommend for someone who may be in their second or third year considering applying for judicial clerkship? What are some things to look for and some red flags that might give them pause?
Things to look for in terms of applying for clerkships. The first is information. The Legal Accountability Project is trying to provide transparent information about judges and clerkship experiences, so students have as much information about as many judges as possible. But it's about identifying judges who people say positive things about, who people candidly are willing to speak about, who hire diverse clerks. Though I think red flags, more important, judges who fire their clerks, judges who clerks seem to leave their clerkship early. In terms of law schools that conduct any sort of post-clerkship survey of their law clerk alumni, if somebody is not effusive about their clerkship, they consider that to be a red flag. Or if somebody writes on their clerkship survey, just contact me, that's also supposed to be a euphemism for mistreatment. Unfortunately, law clerks either don't know that or don't have the bandwidth to hunt around for this information when they are burdened with numerous other job search responsibilities and law school responsibilities. So it is really challenging right now. The Legal Accountability Project is finally trying to provide that transparent information. But if you are a law student considering a clerkship, there's two things you should do. The first is you can reach out to me, the Legal Accountability Project, and I can definitely direct you to excellent judges to apply to. I do that often. The other thing is that the Legal Accountability Project is creating a centralized clerkships reporting database that democratizes information about judges, ensuring that law students have as much information about as many judges as possible before making important career decisions. It will finally increase transparency in the clerkship application process and empower more diverse students to pursue clerkships by arming everybody with the information they need. Because it is disproportionately historically marginalized groups who lack access to information about judges and clerkship experiences through formal networks. Many law schools are considering whether to partner with LAP on the clerkships database right now. If you are a student and you think this would be valuable, reach out to your law school administration, your clerkship director and deans, and urge them to partner with the Legal Accountability Project. This is a resource that every law school and every student deserves access to. LAPs is a mission that every law school should be on board with, and we really just need a groundswell of student support to get this over the finish line. This is the best way to ensure positive clerkship experiences and to ensure that every student has the information they need before applying.
Excellent. So if someone wants to reach out to you, Aliza, let us know how to get to you.
So my email is aliza.shatzman@legalaccountabilityproject.org. Our website is legalaccountabilityproject.org. I love hearing from students and clerks, and I enjoy talking about avenues for student advocacy. I'm also very active on Twitter at Aliza Shatzman and on LinkedIn. And we're really just creating a really amazing community of law students and law clerk and law school alumni advocates on this issue to finally change the culture in the legal community, make clerkships better for the next generation of attorneys.
Thank you so much, Aliza. Thank you for sharing your story, for letting us know what's going on with judicial clerkships, for all the work that you're doing, and for offering to have people reach out to you. That's going to be a great resource. Thank you so much.
Thank you.
Thanks for tuning in to another great episode of Journey to Esquire, the podcast. Support, share, subscribe. And for more, visit www.journeytoesquire.com.